The Honorable Circuit Court for the County of Monroe in the State of Michigan is now in session. Circuit Judge Daniel S. White now presiding. You may be seated.
Top of 11, people of the State of Michigan versus Marshella, Chidester.
All right, well, we are here on a couple of motions, and the question is, why are we here on a couple of motions? So the motion deadline was 9/13. Mr. Clovis filed a request for an adjournment. I adjourned it to 11/8. 4 motions were then filed almost a month late. And now I have 2 motions filed 2 months after the motion deadline. One is framed as a motion in limine. That's fair. There's no deadline on those. Neither raise an issue that were not known about months and months ago. So what's the reasonable cause for hearing this 2 months after the motion deadline, Mr. Clovis?
With regard to the toxicology, we've retained an expert that will be testifying. In reviewing recently, the last couple weeks, thereafouts, with the expert and what took place during the preliminary examination, and then further looking at these records that were recently provided to me, my experts alerted me to a couple issues with regard to the toxicology, the foundation, and the reliability of the blood testing that was done that is going to be wanted to be admitted by the prosecution. So I could not file that earlier, and you have 2 counts, of course, of second-degree murder, and capital offenses, motions, why I respect deadlines, motions could be brought up during trial to protect someone's right to a fair trial and liberty and freedom. And so this isn't, of course, a civil case that deadlines are deadlines and evidence isn't in or defaults are given or dismissals are given for sanctions.
All right, so you've told me there's a reasonable cause for the one motion.
Okay.
What about the other one?
We filed it. They have to lay the foundation with regard to private property, or is it open to the public? Judge, that's certainly, if you want to treat that as a in limine, I will amend it on the record and call it an in limine motion. They can't, that's one of the elements they have to prove. So at least I wanted to put everybody on notice, Your Honor.
All right, well, go ahead and argue the second one about the public property.
Okay, thank you, Judge. The property, I went down to the clerk's office, spoke with the supervisor, and this area is private property, membership only, public not allowed, no trespass. It's not a Burger King or McDonald's or Taco Bell that somebody's driving in that's open to the public. This is completely private. And the elements also, during the preliminary examination, which I've attached to the preliminary examination, that it's private property. The officer testified it's private property. There's no question about it. Nobody said that, yes, it's open to the public. You can't leave your car there, you can't drive there, it's membership only. When I went to the assessor for Berlin Township and also talked to the supervisor of Berlin Township, she confirmed it with me. She gave me a little map, a plat, with regard to it, and said that is all private. The county, the city, doesn't take care of that area, doesn't take care of the road. The people that live there are the ones that take care of that little tiny private road. But more importantly is the parking lot itself is private. It's not a party store that's open to the public.
Okay, I think we established that.
Okay, Judge, thank you. And that's my motion.
Mr. Lorraine?
That, just, if I may, Judge, that would certainly apply to all of the offenses that says operating a vehicle causing death while, under a certain amount of alcohol,
I understand.
causing death, and it would apply to all of those.
Mr. Lorraine?
Thank you, Judge. The statute's clear, Judge, that it's areas that, not just public roads or parking lots, it's areas generally accessible to the public. I think this meets that clearly. As an officer of the court, I was able to drive back there and get to the Swan Boat Club. Every member of the Swan Boat Club does not live in the plat that Mr. Clovis is talking about. There are members who live out in other portions of the county. One of our witnesses is a person who doesn't live within Branchall Road or the surrounding roads, that is a member of the boat club and generally attends there. Therefore, its very existence and the fact that they allow members that don't live there shows that it's generally accessible. People in their response cited the Ray case, which is kind of the nth degree generally accessible case in the state of Michigan, that says that all of our driveways are considered generally accessible. Those are clearly private property, not open to the public. My subdivision is private. We clear all our roads. That doesn't mean I can get drunk and go tooling around my subdivision. People think that the evidence will come out at trial that this is generally accessible. None of the emergency responders, none of the guests, none of them had to pass any checkpoints, none of them had to go through any gates. This is an area that's generally accessible to the public under the statute.
All right, you get the last say so, Mr. Clovis.
Please, thank you. Your Honor, this is members only, private boat club. If somebody does enter that's not invited guests, it's trespassing. They can be arrested for a misdemeanor. You don't have to live down the street to be able to enter the club. If you're invited guests or a member, you can drive into the club legally. So living around the area, that has no relevance whatsoever. And then lastly is a driveway is private. And I understand the Court of Appeals case, but that was whether somebody had just driven recently the person's own house where he was drunk driving, and they upheld a conviction. But this is like, Judge, for me to show up at your house and pull up into in your backyard, and I've been drinking.
Don't do that.
I promise you, Judge, I would never do that because I really don't drink.
Okay.
So, but it's private. You can't, that is private. If you want to talk about earlier, Mr. Clovis or whomever was driving on public property, that's something different in inference. But this is strictly private, and it's members only. Thank you.
All right, well, the statute is crystal clear in my mind. You shall not operate a vehicle on a highway or another place open to the general public or generally accessible to motor vehicles, including an area designated for the parking of vehicles. That then is further elucidated by People versus Ray. There's no question this falls underneath the statute. This motion is denied. Go ahead with your next motion, Mr. Clovis.
The next motion is the toxicology.
Yeah, we're treating it, however, as a motion in limine.
Okay, Judge, well, all right. I actually need a evidentiary hearing, or I need a hearing to have the officer here to confirm what he had said. I presume this was going to be not an evidentiary hearing today on it, and I would ask any time next week, Your Honor, if you would, respectfully, if you could set it for a hearing.
Well, let me just go right to the point. All right, so I'm looking at your motion, and your motion says the people are going to have the attempt to have the blood test admitted at time of trial. They have the burden of establishing the foundational requirements. We all agree. We agree on what those foundational requirements are. Your motion then goes on to say that you strongly suspect the people cannot establish the foundational requirements for the admission of any blood testing results of the defendant. That's what your motion says. When we were here, I don't know if it was last week or 2 weeks ago, I said, well, I'm going to have to see some law. There was an amended motion, now an amended motion to suppress, but it says the same thing, that you strongly suspect that they can't establish the foundational requirements. That is what you're saying.
Right.
That is, sum and substance is what you suspect.
They can't lay the proper foundation, and I would rather not have that at the time of trial to taint a jury.
Don't I need more than you telling me this is what I suspect they can't meet? Aren't you supposed to tell me something in this motion that says why you suspect they can't meet it?
Well, they have the burden. I don't have the burden of the foundation. Just like a Walker hearing, they have the burden, and a Walker hearing is heard on statements and Miranda. Prior to a trial, I don't want the trial to be tainted by hearing a foundation being laid that turns out that it's an improper foundation, and the jury is already tainted by hearing it. So it's almost the jury's accepting whether a foundation or not. And so it's only fair with 2 counts of murder that a hearing be scheduled. We have all of next week, respectfully, for a hour and a half hour hearing with regard to the foundation. I don't believe the blood may have been drawn properly, but I don't believe the blood was preserved properly.
It doesn't even say that in your motion.
Well, I guess, Judge, I'm informing the court that during the preliminary examination, the officer said that he never shook the preservative whatsoever, which he's supposed to do.
All right. Mr. Lorraine, your response.
People just stand by their response, Judge. It's a trial issue. If people can't lay their foundation during trial, Mr. Clovis, I'm sure, will object to that. The court will have to rule. And absent a Daubert hearing way in the past from today, I don't know how else the court handles it at this stage of the game.
Your Honor, may I respond?
Yes, always have the last chance.
Your Honor, that the vials, both vials, as the court's aware, have a powder in it for a preservative. The blood was put in there. The officer testified at the prelim, and it was never shaken. He is supposed to shake it by statute. Or guideline. He was supposed to shake it because that preservative is what keeps it from being, instead of a .02, turns into a .18 if the preservative is not shaken. And so he testified to that already, sworn testimony. So that's just one item that he didn't do proper. I believe there's more than one.
All right. Well, again, this is as a motion in limine. Both motions only say that the defense suspects they might have a problem establishing foundational requirements. None of what Mr. Clovis is testifying here to is in his motion. You need something more. You can't you can't have a trial run on the trial issue. If the foundation is not properly laid, just like any other objection, then the court's not going to let it in. For those reasons, the motion is denied.
Your Honor, I would ask if the court, with regard to the foundation, that be outside the presence of the jury prior to the testimony before the jury. In other words, that foundation is laid, and then if the court admits it, then the trial continues in front of the jury. If the court does not admit it, they have not been tainted by any testimony and is excluded. I would ask that be done outside the presence of the jury.
Mr. Lorraine?
Well, Judge, the foundations for the blood, by my count so far, I might have 6 witnesses. So without a more definite statement of what we're dealing with here, what we're concerned about having outside the presence of the jury, and also the blood result can't come in until the very end of that. So I don't know what taint Mr. Clovis is concerned about, because that taint wouldn't come until the very end of those 5-6 witnesses.
All right, I'm going to stick with my ruling. The motion is denied.
And so, Your Honor, the foundation and all that be in front of the jury?
Yes, like any other trial. A couple of other issues that we need to deal with. The jury instructions are due on Tuesday. That's a deadline that must be met. It must include the witnesses you're actually going to call, and those should be in the instructions. The format must be suitable for the presentation to the jury. Also, I had pretrial services send the prosecutor and Mr. Clovis a copy of an email they sent to me regarding irregularities concerning the scram tether that Ms. Chider is wearing. There was an obstruction on February 13th and an obstruction on February 14th. Both of those obstructions lasted 12 hours. Then there was a testing in probation that may have indicated the presence of alcohol. Do you like to address that, Mr. Clovis?
Certainly. Your Honor, we did do testing. We were notified. We went down to probation. It turned out, or at least some of the facts are, that, and the scram person that's here in the building, is that it was very loose. Her leg had swollen up because she had surgery, and so the scram unit was expanded by him, Jeff, and then the swelling went down, and it was very, very loose. And so he noted that the other day, a couple days ago, when she came in for this alleged violation or notice. And so he tightened it. He saw that it was very, very loose. So I think that's what may have caused it. Certainly, the most she wears is a nylon, and that doesn't affect it. But a loose mechanism on her leg certainly could have been that. We don't know. But he did tighten it. It was quite loose. And he noted that. As to the alcohol reading, the actual alcohol reading was a .01. And I think it started off at a .018, thereabouts. My client and her husband, no alcohol is allowed in the house whatsoever, couldn't figure it out. And we went down and met with her. It turned out that she had this bottle of whatever flavored water, and that may have done it. But then, her husband, and can testify today, he has the strips. There's tea that she drinks, and the tea didn't show anything at all, but she drinks it with honey. She put the honey in, stirred it like she does, and put a strip in, and it showed faint alcohol showing up. A .01 is a .02 and higher is illegal for a minor to have in their system. .02 and higher. Anything below .02, it's not illegal for a minor by statute. It's not considered alcohol under the influence. So I don't know what occurred, but I know a .018 is beyond low. It's extremely below low. And so therefore, Judge, the results, I do not believe strongly, I do not believe that it's indicative of having alcohol in her system or consumed any alcohol whatsoever. Again, if it was a .03...
All right, when we say again, we're just kind of saying the same thing. I got what you said.
All right, Judge.
I do agree with you that the alcohol is low. There's a lot of things that could factor into that. I can't necessarily or wouldn't necessarily take any action with respect to that. As to the obstructions are lasting 12 hours. So they're loose for 12 hours and then they somehow tighten themselves up again. I have some real questions about that, but nothing definitive. I'm just putting Ms. Chidester on notice regarding any of the obstructions regarding this, and I'm directing her to go immediately from leaving this court down to pretrial services and have them test her again. If the tests are fine, we'll see you a week from Monday. If not, we'll see you later this morning.
And Judge, if people could speak to the bond violation just briefly.
Sure.
Just people's understanding of it is that pretrial services ran into these issues, prepared a report on them, but didn't believe that they would be able to meet their burden in a bond violation hearing. people understand that that's pretrial services position. People just want to put on the record that if there is a supported bond violation in this case, particularly one related to alcohol, people are going to be vehemently moving for remand.
Understood. All right. Anything else that we need to talk about?
Nothing, Your Honor. You have a pleasant weekend.
All right. Thank you.